Okay, welcome back. One of the big cases out there today, and certainly stories, is the birthright citizenship that was done through an executive order with President Trump in eliminating those. So it's very timely for us to have back with us today Mark Miller, senior attorney there with the Pacific Legal Foundation, and you can go to pacificlegal.org. And this organization is out there on the front lines in your behalf. So check out their cases, go to their website, and support them, pacificlegal.org. Mark, good to see you again. How are you?
I'm doing very well. Thank you, Perry. Great to see you.
Thank you for your time. All right, so what about this case? Where's it going? What do you think?
Well, Perry, after today's decision, which we might want to talk about later, on the Catholic schools, whether they can be Catholic charter schools can be public, deadlock today 4-4. And so I bring that up. It just happened. It's breaking news because it affects the birthright citizenship case because it's a bit of a surprise. I expected the Supreme Court to say that public charter schools can be Catholic. You can't have charter schools that are non-religious and then not allow religious charter schools to be public as well. But the Supreme Court didn't see it that way. So with birthright citizenship, where I thought the court was prepared to say X, Y, and Z coming out of last week's oral argument, now I'm not so sure what these justices are really up to. It presents two very important issues, Perry, which you know. One is how much power does a district judge, one lone district judge, have to stop the President of the United States? And two, how much power does the President have to change the law when it comes to birthright citizenship? So this birthright citizenship case presents two very important and big issues.
Okay, so how do we unpack this? Do you think, what's your take on the birthright part of it? Where do you think that's going?
Well, I think President Trump has got a tough hill to climb, Perry. The court did not seem too friendly to his idea that somehow 150 years of the Supreme Court saying birthright citizenship in the 14th Amendment means if you're born here, you're a citizen. They didn't seem too sympathetic to the idea that that's not what that's not what the writers of the 14th Amendment meant. President Trump has an argument to make that the text of the 14th Amendment does leave wiggle room to see it the way the president argues, which is just being born here isn't enough, that you also have to be, the language is subject to the jurisdiction thereof, is what the 14th Amendment says. And what the president argues, and some experts agree with him, is that if you come here illegally, if the mother and the father come here illegally, they know they're breaking the laws of the United States when they come into the country, then they don't say that they're subject to the jurisdiction of the United States, that they don't have to follow the law. And so effectively the president is saying, you're not subject to the jurisdiction, so you're not, if you're a baby born here, you're not actually a citizen. The justices didn't seem too sympathetic to that. They sort of made the point sort of implicitly that, well, if that's the way we're going to look at it, then what country are those babies children of? Are we going to visit the sins of the parents, if you will, the crimes of the parents? If you say coming in illegally is a crime, are you going to visit that on the children? But at the same time, you still have that same issue of one district judge who's really one of 300 some odd judges overruling the President of the United States in the nationwide injunction issue. So it's complicated.
Okay, let's camp there just for a moment. What's happening with these district judges, Mark? Because it seems to be obvious. These are political road bumps and speed bumps and all of that. But do I understand it correctly that the merit of a case could be appealed to the Supreme Court, but the jurisdiction of the district court comes from Congress? Is that right?
Well, Congress can take away the district court's authority to have anything to do with this. The courts ultimately are a creature created by Congress. The Supreme Court is part of the Constitution, but everything that comes after that is Congress creating. So the appeals courts, the district courts, all the rest. So indeed, the district courts can be taken out of the loop. But for now, the district courts do have the power, until the Supreme Court says otherwise, to overrule the president, to enter what's called a nationwide injunction, and just simply say, we are going to block the president when he tries to rewrite the law of birthright citizenship by way of an executive order.
Do we want the Supreme Court dealing with the jurisdiction of the lower court?
Yeah, I think, Perry, we absolutely do want to see the Supreme Court weigh in here. I think the court itself recognizes that for one district judge to be able to overrule the president, unless it's a very egregious situation, probably shouldn't work that way. The judges, are appointed for life, and they do have to decide what's constitutional and what's not constitutional. But whether they should be able to block enforcement of the law for the whole country is a whole nother question. From a question of jurisprudence, Perry, we want the trial judges to rule really just on the issues and the parties in front of them, so that other judges can hear the same issue and perhaps rule differently and provide a different analysis. And then the Supreme Court takes all these different rulings and it harmonizes them. It decides, it can look at all these different ways of, peeling the onion, if you will, and decide this is the best way to resolve the question. But when one judge decides for the whole country that there's only one way to look at things, then the Supreme Court doesn't have the benefit of all the different analyses. So from a practical perspective, the idea that one judge through a nationwide injunction can make the decision for the whole country probably shouldn't be the case, unless what the president or Congress has done is so blatantly unconstitutional that maybe the judge should be able to, in the worst situations, block it. And Justice Sotomayor, to her credit, gave you a good example where maybe you would want a district judge to be able to block a law for the country, when she said, what if the president, not President Trump, but a future president, were to say he is seizing all the guns in the country? There, we might say it makes sense that one district judge could block the president. But unless it's that egregious, we probably don't want district judges having that kind of power.
So is this an ambiguity in the system, so to speak? I mean, doesn't the term district take on meaning here?
Yeah, Perry, it absolutely is an ambiguity in the system. And what's very intriguing about President Trump, whether you love him or you hate him, or somewhere in between, which I don't know if there's anyone in between, he pulls out the ambiguities in the system and he says these ambiguities need to be resolved. And he's got a particular perspective but on how they should be resolved. But his point is, this is ambiguous. And so the question of birthright citizenship, whether or not you agree or disagree that he can overwrite 150 years of Supreme Court law, he has a point when he says the 14th Amendment does have some ambiguity. So whether it's nationwide injunction or the 14th Amendment birthright citizenship, the Supreme Court ultimately does have to make that decision to resolve the ambiguity. And that's why the case is in front of them. They often don't want to resolve the ambiguity. They only want to resolve as little as they have to. But President Trump often doesn't give them a choice. And I would say that's to his credit at the end of the day.
I understand that. So one last question before I take a break. So at the end of the day, what's happening here, the executive powers are now not only being challenged, but they're almost being muted, right?
Certainly, if you want it, it depends on what we're talking about when it comes to the president. If we're talking about, say, his ability to remove people who have court orders to be removed, who are alleged terrorists, if you will, Tren de Aragua, or the other sort of criminal organizations that exist where illegals are here violating our laws and pillaging. There, he would say, look, the courts are basically interfering with my ability to execute the laws, which is the president's power. The executive branch is supposed to execute the laws as Congress has passed. Certainly, that's what Stephen Miller would say, sort of number one political advisor on immigration issues. Conversely, the courts would say, and I'm not trying to take a side here, but just to make both sides of the case, the courts would say, no, our job is to make sure that due process is being afforded. The president says, I am giving due process. These people are terrorists. And the courts and the parties representing these people who are here from overseas, they're saying, well, there has to be a court hearing on it. I'm going a little bit far afield of the birthright citizenship, but that's because there are so many cases where the president's powers are being hemmed in by the courts, and you kind of have to talk about all of them to talk about any of them.
So on the due process case, Mark, I'm a little over time here, but on the due process issue, there's that term, all peoples. And the question is that all peoples, everybody inside the United States, or does that mean citizens?
Well, certainly, Perry, we have understood the general concept of due process, the general concept of habeas corpus, which is the idea that somebody who's being held by the government has a right to challenge the government and say, you don't have the authority to hold me. That dates back even before the country, certainly in the Constitution, but it dates back in Western law all the way to Magna Carta, which was sort of the charter of our first individual rights in 1215, if you can imagine, nearly 800 years ago, well, more than 800 years ago. And so this concept that the president can be challenged when he's holding somebody against their will, saying they're not supposed to be here, that's fair, and that applies to everyone, citizen or not citizen. Because in reality, even if you're not citizen, what if you're a citizen and the government says you're not a citizen? You should have the ability to say, I am a citizen. I'm not a citizen, not a citizen. So, it's a bit of an angel's dancing on the head of a pin. And it's a question of how much due process you should get. To be sure, an American charged with a crime is entitled to a lot more due process under the Constitution and the Bill of Rights than a non-citizen who is being deported. But the question is how much due process. They certainly get some.
Yeah.
Even the terrorists who did 9/11, Perry,
Yeah.
were entitled to due process. And so that's the question, is how much?
Okay, I got it. Let me take a quick break. Check out Mark's website, pacificlegal.org. Again, the Pacific Legal Foundation there on your behalf, working on these cases, pacificlegal.org. We'll take a quick break. We'll be right back. Okay, welcome back. Mark Miller is back with us today, senior attorney there for the Pacific Legal Foundation. Can't say enough about this organization and what they do in your behalf. They're frontline warriors. You can go to pacificlegal.org as their website, track some of the cases that they're following and the ones that they've won. And let me say, if you feel led, support them because they're there for you. Mark, I want to come back to the headlines breaking about what's happening in Oklahoma on religious charter schools. This is so interesting. Basically, the Oklahoma Supreme Court said no to religious charter schools from receiving state funding. And that was appealed to the Supreme Court, and the Supreme Court has upheld the Oklahoma Supreme Court. There's a couple things here. First of all, the Catholic school that was involved agreed to meet all state requirements and open the school to all students. But that apparently didn't appease the court. And then secondly, how damaging is this to religious schools? Because it seems like it further puts religious schools over here fighting the requirements of public education.
It's very frustrating, Perry. The school choice movement, which Pacific Legal Foundation has proudly been a part of for years, has made tremendous strides in terms of making the point that if the state can fund non-religious schools, then why can't religious schools be funded too? We're all trying to do the same thing, which is teach children, the 3 R's. And so isn't it just a violation of the First Amendment to say we're going to fund non-religious schools, which at the end of the day is a kind of religion. It's a non-religion, but you know what I mean. But then you say we can't fund religious schools, in this case, a Catholic school. Oklahoma does allow funding of private Catholic schools in a sort of convoluted way, which happens in a lot of states. But what the Catholic schools were trying to do here in Oklahoma was say we can actually be a public school, be an actual just simply alternative to your local regional public school, your district public school, if you will. And we should be funded as long as you said, we abide by state rules. Otherwise, I think if you're a religious person, you might have to pause on that question and say, well, oftentimes he who pays the piper calls the tune, and there's a risk to that. But as long as the religious school says we can follow the state rules and also educate the children, shouldn't the parents have the right to choose where their kids are educated? Why should the state pick and choose winners and losers and say these kinds of schools we can fund, religious schools we won't? And there was a lot of hope that the Supreme Court in this decision would say that's correct. Most of the Supreme Court school choice cases over the last decade have been going that way. Here, Justice Amy Coney Barrett did not participate in the case, probably because the Notre Dame Law Clinic argued on behalf of the Catholic schools. We don't know why, but that's a good guess. And so the decision was 4-4. We don't know how they voted, but we can guess that the 3 Democrat appointees voted against the Catholic schools, and at least 4 of the Republican appointees did, and one of the Republican appointees, Chief Justice Roberts, perhaps, or Justice Kavanaugh, switched and voted against the schools. And so it was 4-4, and that means the Oklahoma Supreme Court decision against the Catholic schools seizes the day, wins the day. Perry, I want to make one point for your listeners, because nobody would say this is the part of the country, of the world's school choice movement, that the country would be surprised by. In Canada, Catholic churches do have public schools that are run by the Catholic Church, and nobody would say nobody would say that Canada is controlled by Catholics. It would be ridiculous. But in fact, there are Catholic public schools in Canada, and the parents can choose to send their children to Catholic public schools. In fact, my daughter-in-law teaches in one of them outside of Toronto. It's a total normal thing in Canada. Here, we seem to be hung up on the idea that somehow the Catholics or the Christians are going to put their religion into the children. Let's let the parents decide where the kids should get educated. It shouldn't be bureaucrats. It shouldn't be justices. We shouldn't be picking or choosing who gets funded and who does not, as long as we're getting a good education.
Is this a blow to school choice?
Yeah, Perry, absolutely. It's a surprising outcome. Chief Justice Roberts really has been a leader until now on recognizing that if you're going to fund private, non-sectarian, non-religious schools, you have to allow the funding of Catholic schools or Christian schools. The idea that it's a leap to take that logic that Chief Justice Roberts has endorsed and apply it and say there can be public schools that are religious, it shouldn't have been a leap. It's just common sense logic. The logic should flow that if it's okay in the private sector, then it should, that states can fund private schools that are religious, then why can't they be public? At the end of the day, as long as the parents are choosing to send their kids there, what's the difference? But unfortunately, the Supreme Court appeared to get skittish. We don't know because they didn't write an opinion, but they appeared to blink on what could have been a massive win for the school choice movement. It's very disappointing.
Can it be appealed, or is this it?
This is it. And, Perry, I said it's a loss for the school choice movement, but more importantly, it's a loss for our children and for parents. And let's hope the court revisits this soon, and Justice Amy Coney Barrett agrees to participate in that next case. It's unfortunate that she felt she had to recuse, give her full credit that she didn't want to appear biased. But it's our children and our parents who lose when we take away school choices from them. The kids need a good education. Catholic schools in this country, Christian schools in this country give an excellent education, and nobody forces religion down their throats. Instead, they teach them the 3 R's, and goodness knows that's what our children need.
Yeah, boy, this is quite a turn today. One other quick question, Mark, before I run out of time. I want to come back to the district courts interfering with the executive branch. I'm really confused. What can the president, who can he deport these days? On one day, nobody, some days, some people. I mean, who's left?
It is hard to follow the logic of each decision. For example, either yesterday or the day before, the Supreme Court said pretty much almost unanimously, I think only Justice Jackson objected, that Venezuelans who are here legally, temporarily, can be deported. And so to me, that was very peculiar, because here we have illegals who are not here, and I don't like to call them illegals, but they came in here illegally, whatever you call them. And we say that they can't be deported, but we say these Venezuelans who are here temporarily, approval of the government, now the government's changing its mind, they can be deported. There's an analogy, Perry, that I like in the immigration context. We want to shut the back door, but when it comes to the front door, when people try to come in legally, we should be encouraging that, because that's what America's been about. That's what the Statue of Liberty is about.
Right.
We hear the Supreme Court saying these people who came in through the front door, you can kick them out, but the people who came in through the back door illegally, maybe not. And it doesn't make a lot of sense, and it makes you wonder, what can the president do?
Yeah, I mean, at the end of the day, I mean, you come over the fence, it's wrong. You come through the door, we'll process you.
Yes, exactly.
So where does this end up? What do you think? I mean, some of it's national security. Some of it is breaking the law. I find it interesting that an illegal citizen can come into a sanctuary city, commit a crime, and be protected. I mean, they're illegal in the first place, then they come in and then they break the law and somehow they're protected. I think it's leaving us all on tilt.
Yeah, it doesn't breed respect for the rule of law when it seems like it's more being decided on an ad hoc basis. And so the Supreme Court does need to figure this out and make like a final decision. I think I wouldn't be surprised to see something similar to what happened in President Trump's first term, where the president was trying to say, I'm not going to allow immigrants from certain countries. And initially they were just Muslim countries, and they said, well, the president's being discriminatory against Muslim countries. Whether or not you believe that, what the president did in response was he said, okay, we're going to also block North Korea. We're also going to block non-Muslim countries that we consider dangerous to the United States. And then the Supreme Court said that was okay. And so here, I think you will see the president's legal team keep changing the executive order, amending the executive order until the Supreme Court says, okay, you got it right now. That might not be the best way to do things, but it's just a better option than any other option that we have.
Mark, you've been very generous with your time. You're a busy man. Thank you so much. We so value you and your organization. Let me say to our viewers and listeners, check out pacificlegal.org. There's a picture of their landing page. The cases that they're involved in and the ones that they won are very, very, very important. So check it out. If you feel led, certainly support them, pacificlegal.org. Thank you, Mark. God bless you, friends. Stay in the fight.
Thank you, Perry.